moving on. So we jump forward a little bit of time. We jump forward to 1992 in Freeman v. Pitts. Justice Kennedy writes the majority opinion in this case, and while at first glance, this case is unanimous, I want you to recognize that there's a very significant division on the court at this time. So despite the vote being unanimous, there's a very clear separation in terms of two camps on the court. So first off, just before this case was scheduled for oral arguments, Justice Marshall, remember, dissenter in Milliken, announced that he was retiring. So the civil rights champion of the 40s and 50s, who joins the court and helps steward in many of these changes, has announced he will be retiring. And while he hasn't joined the court yet formally, Justice Thomas has been appointed and doesn't take part in this case. So Marshall was always and consistently a proponent of federal court supervision, and was very, very upset with how the court backtracked in the 70s. So the court is sort of primed to make a change. So looking at the court as it decides this case with 8 justices, 4 agree with Kennedy. The 4 others write a concurring opinion. So you have 4 conservatives who agree with Kennedy, and you have 4 liberals who don't. And so because of these divisions, one could go so far as to say that this case pretty much closes the Brown era, that this case marks a signaling to the end of the evolution from desegregation to integration to the shutdown of the Brown era, that this case is sort of the door that closes that progress and puts an end onto especially sort of district court ordered reforms. So what are the facts of this case? Well, this case is concerned with DeKalb County, which is a significant suburb of Atlanta. It happens to be the largest school system within Georgia, and it still to this day remains one of the largest school systems in the country. The DeKalb schools had been subject to supervision and jurisdiction of the Northern District of Georgia, so the District Court of Georgia, since 1969. So they had been a jurisdiction that had been supervised and directed by the district courts since 1969, when it was formally ordered to dismantle its de jure dual public school system. So basically a school system that had one track for whites and one track for African Americans. So this oversight had existed since 1969. In 1986, the board filed for final resolution. Basically, final resolution is saying, hey, can we get out of the oversight of the district court and begin running our school systems autonomously? So the district court holds a hearing to that regard, and says that the school board had received what is known as unitary status, which is simply to say that desegregation and integration efforts had been successful. So the district court says that this unitary status has been achieved in 4 particularized areas, but not every single area that the district court was tracking. So in 4 areas, they had come up to standard, but in other areas, they simply hadn't. So what the district court does is the district court, instead of giving the DeKalb County School Board exclusive control, it relinquishes control over those 4 areas which they've met unitary status, but keeps control over the other areas where the school system had not met compliance. So basically the district court said you can have these 4 areas back exclusively under your control, but all of these other areas where you've not quite met compliance as we judge it, we maintain oversight. Obviously, the district appeals that decision, and the 11th Circuit reverses that decision. and overturns the decision of the district court, basing its decision on Green. Remember back to before COVID-19, back to Green, because Green's holding said that the district courts should have full remedial authority over a school system until it receives unitary status in 6 categories at the same time for several years. So they cite as precedent Green, which says that no, for district courts to give up control, these local district school systems had to have had unitary status in 6 categories for a number of years. And in Freeman, very clearly, the district court has said that there were only 4 categories that they met. So since the last guidance the Court of Appeals had into this was Green was really the last precedent that they had to go on, the 11th Circuit overturns this case. So the Supreme Court takes this case and overturns the Court of Appeals, ultimately charging that the district is permitted, the district court is allowed to withdraw judicial supervision with respect to discrete categories in which the school district has achieved compliance with the court-ordered discrimination plan. So in essence, the Supreme Court unanimously, remember, modifies the precedent in Green and says that district courts can give up particularized categories as the school district meets compliance with them. So it achieves unitary status. And that differentiates it from Green, sort of modifying Green almost a little over 30 years after the fact. So ultimately, the Supreme Court held that the federal courts did not need to retain entire jurisdiction over every aspect of the school system, that it could give it away in certain aspects when compliance is met. So total compliance isn't necessary, and districts are allowed to withdraw their supervision in those areas when compliance was achieved, and that number of years and areas of compliance, so all 6, were not necessary. So if they simply met compliance in a year, district courts could give that back. And understand this was Justice Kennedy writing. So Justice Kennedy's decision, his majority opinion, went a bit too far for Justice Scalia. Justice Scalia, in his solo concurrence, argued that there should be an immediate end to all judicial supervision of schools that no longer intentionally discriminated. So for Justice Scalia, oversight for school systems that were still actively discriminating was necessary. But if they were no longer intentionally discriminating, remember, difference between de jure and de facto. For Justice Scalia, if they were no longer intentionally discriminating, then district courts should be required to give up all jurisdiction and all supervision. He agreed with the majority that this system, as it worked, was in the Northern District of Georgia, was correct in giving up sort of individualized control of those 4 areas, but he wanted to completely get federal courts out of the business of running school systems. So at the same time, the 4 judges who concur that sort of strike a different tune are Blackmun, Stevens, O'Connor, and Souter. And in separate concurrences, the justices argue that lower courts should engage in probing analysis of the district's record before abandoning desegregation efforts. So those who agreed with the majority opinion, but very clearly had a different reason, said that, well, there still needs to be a large degree of oversight here, but as school districts come in compliance, they can have their supervision given back to the school districts themselves. So it's a unanimous decision, but it's not unanimous. It's unanimous in the decision of the case. Everyone in the case agreed with the outcome generally, but some, like Scalia, didn't think it went far enough And others, like Blackman, Stevens, O'Connor, and Souter, thought it went way too far. But they agreed with the outcome in the particularized case. So even though this is unanimous, it's not unanimous in terms of how the law is evolving. So in the outcome, it's unanimous, but in the overall picture, it's not. And you can see very clearly how this marks really the end of the Brown era. Are there any questions about Freeman as a sort of closeout? Okay, Andrew. So between these cases was the progression pace on track with planning. I don't know what you mean by that, Andrew. Let's see if I can find you. So Andrew, you're unmuted if you want to start talking.
All right. So what I meant was like in the previous group of cases that we were in, you were saying that some of the groups had gotten together and that they wanted to plan like how far they could get within a certain period of time.
Yeah.
And that's what I meant.
Okay. So yeah, that progression, so that move from just desegregation to integration, it sees its peak in Swan. Swan is by far the most reaching integration case. Every case after Swan is the court pulling back on integration. So in Milliken, that idea of pushing forward is gone. They're pulling back. So remember, the 5 justices in the majority are no longer pressing integration as far. In fact, they're saying that, whoa, the district court judge took it too far, and we need to rein it back in. When you get to Freeman, the court is going, well, if a local school district has met the requirements of desegregation, that language is important. Desegregation, not integration. But if these local schools have met the qualifications for desegregation, then the district court can simply pull back and there's no need for oversight. Those 4 judges that thought that this decision went way too far, Blackman, Stevens, O'Connor, and Souter, weren't nearly as sure that that was a right decision. So it's not like in 1992 or at some point in the intervening years between 74 and 92 that desegregated school systems shrank up and hardly didn't exist. There were still school systems, both in the North and the South, that were segregated, either de jure or de facto on the basis of race. And while DeKalb, by everyone in the majority agreeing, had made a lot of progress to solving that system, so solving the problems of desegregation, that wasn't true everywhere. And so that this decision goes much farther and says that no, district courts can make the determination about when to give oversight back to the school districts, and basically the district courts judges give it up. Those 4 judges didn't think that that was a good idea. And primarily because they could look around and see that some of the reasons why these school systems were complying with these desegregation efforts was because of the fact that the district courts maintained control. And that if these district courts pulled away their control, that there was a likelihood that at least in some areas, in some cases, that these district school boards would go back to either a de jure or de facto segregated system. And so that's why you see this real disconnect in the court. But by the time we get to 1992, desegregation efforts aren't popular. And the oversight role that a lot of these district court judges had to play was also not popular even amongst themselves. Imagine if you're a district court judge in, let's say, northern Georgia, as the judge was here, one of your main duties is making sure that the DeKalb County School Board is meeting these sort of desegregation requirements. That's not something that most of these judges got into justice for, not something they signed up for, because they're basically playing an administrative role instead of playing an adjudicative role. And so I think this decision, as sort of a closeout to Brown, an ending of Brown, there are a lot of moving parts going on, Andrew. And I think that while a plurality of judges, Blackmun, Stevens, O'Connor, and Souter, were sort of reticent about giving up control, they also saw the writing on the wall. Because you have to remember, after Marshall leaves, it's Justice Thomas who joins the court. And Justice Thomas is, of course, going to side with Kennedy and Scalia. And the decision in this case is a compromise in that it's unanimous. But if you had Thomas on the court, there's no need for a compromise. You can win 5-4. Understand, if there wasn't a compromise in this case, and this is an important thing, if there wasn't a compromise in this case would have been 4-4, which means that the lower court precedent would stand. And the lower court precedent was the 11th Circuit saying that no, local district court, you can't actually release jurisdiction until they've met compliance in every area. So they compromised in order to get a decision that simply wasn't giving the 11th Circuit its victory. And so the four people who I would think of them in the minority, despite the fact they're not, but those four judges sort of saw the writing on the wall and realized that unless they made this compromised decision in 1993, after Justice Thomas joins the court, they don't really have a role to play, because a 5-4 decision doesn't have to include them. Any other question on Freeman? No problem, Andrew. Okay, Kimberly. So this case was a beginning where there is actually a change on the schools where they fully don't accept the segregation. Yeah, so when the district court ruled that in those 4 areas that they could give control back to the school boards, what they meant is they had certain checks that they had to meet. And in this particularized case, the DeKalb County had met 4 of those requirements, that they had desegregated in those 4 areas, or those 4 ways of measurement. They hadn't in the last 2, but they had in these 2. And so it allowed the school systems to be autonomous in those areas, but not the 2 that they had not met compliance with.